And here's the big focus story this evening. The Supreme Court has refused to grant anticipatory bail or relief from arrest to a man accused of taking nude photographs of a minor girl and then threatening to leak them. The top court reprimanded his action, saying that they do not tolerate such actions in our society. The accused, who is booked under POCSO, had allegedly blackmailed the minor on her refusal to get intimate with him. The lawyer appearing for the complainant had contended before the High Court that the petitioner was in a relationship with the girl while she was a minor and took offensive photos and videos of her. The counsel appearing for the accused told the bench that he had joined the investigation and is fully cooperating with it. In a terse observation, the top court says, how can you take a nude photograph and then threaten? The top court added, saying, as on today, the 164 CRPC applies and the statement is against you. There are many. These are very serious allegations. So the top court clearly observes that the allegations against the man are very serious and bail cannot be granted to the accused. Well, this is the case that we are looking at closely today. On one hand, of course, this sets a strong precedent. It's a rare reversal of the bail not jail norm that the top court itself had weighed in very heavily in favor of granting bail to the accused, strongly denouncing the practice of prolonged jail terms. However, this case is some sort of an exception then, where the top court feels that the accused should not be granted bail. Let me welcome here on the program, joining us this evening is Advocate Ashutosh, well-known author, Rekha Aggarwal, advocate, and Ashutosh Srivastav, again, advocate, joining us on the panel. Thank you so much for joining us. Let me begin with Rekha Aggarwal. I just want to begin, by reiterating what the top court has observed. It's a clear refusal to grant anticipatory bail to this man who is connected to a case lodged for alleged sexual offences on a minor under the Protection of Children from Sexual Offences Act, that is the POCSO Act, saying that it does not tolerate any such activity where the offensive photographs of a young girl is used to threaten her. Do you consider this a rare reversal of the bail not jail norm? Would you welcome this move?
I would say over here that post Nirbhaya, there have been major changes in our criminal legal system. And not only has the definition of rape been enhanced as far as major girls are concerned, but in 2013, we have this very specific law for protecting minor children, which includes both minor boys and girls. In fact, the POCSO law is the only gender-neutral law that has come to protect little children from sexual offences. There is no other law besides the Indian Penal Code to protect minor boys. So the zero tolerance principle has now come into play post Nirbhaya. Any adult girl has a right to say no. And as far as children are concerned, they are such innocent children that in fact, many a time they do not even know that what kind of sexual offense is taking place against them. So as I just said, that post Nirbhaya case, which happened in December 2012, the criminal legal system in our country has become extremely stringent, especially where sexual offences are concerned. And as far as minors are concerned, there can be no pardon or there can be no compromise at any cost. So I fully agree, with the judgment of the court denying bail to the accused. In fact, there can be no question of any temporary relief or bail also to any person who has been accused in a POCSO case. And I'm very, very glad, in fact, that a judicial system has recognized that not only has the law been passed on paper, but also in action. The courts are realizing that though our legal system is in favor of granting bail and not jail, that is the maxim that, why punish under trial without, holding him guilty ultimately. But even as far as, during the pendency of the case is concerned, I think such kind of judgments send a very clear signal to the entire society that you will not message, even be given the temporary relief of bail.
That message, of course, like you mentioned, very important for our society. Ashutosh Srivastav, to what extent do you concede? POCSO involved, minor girl involved, the court says we do not tolerate these instances. So it has literally set aside the bail not jail norm for this case.
See, whenever any FIR is registered, in any case, like in POCSO in this case, the first thing is that after the registration of FIR, the investigation comes into motion. It is not an evidence, but it is a piece of information being given to the police authorities so that the investigation can be conducted. Now, when somebody goes and approaches the court for anticipatory bail, when the accused feels that he may be arrested in that particular FIR, the court generally considers the kind of allegations, the seriousness of the offences.
Okay, I'm interrupting you here, Mr. Srivastav. Extremely sorry. Well, let's now shift our focus back to the big focus story. We were talking about the top court declining bail to a POCSO accused, one who threatened a minor girl with nude photos on her refusal to get intimate with her. With me is Supreme Court Advocate Ashutosh Srivastav and prominent citizen, well-known author Advocate Ashutosh. Thank you for joining me once again. Welcome back. Ashutosh Srivastav, I'm sorry I interrupted you when you were speaking about whether you agree with this observation that the top court has made that there can be zero tolerance for a blackmailer when it comes to a minor child and when it comes to POCSO.
See, as I said, that whenever an FIR is registered, it is not any evidence or any proof. It is something which keeps the investigation into motion. So if a victim feels that he or she has been victimized and crime has happened against them, can approach the law enforcement agencies like police and can register the FIR. And thereafter, it is the duty of the investigating agency to conduct the investigation. Now, the accused person against whom the allegations have been made can approach the concerned court and apply for anticipatory bail when he feels that he may be arrested by the police for custodial interrogation. Now, the court, while considering the petition for bail, has to see the seriousness of the offences which have been alleged and also to see if there is any criminal antecedent against the person.
Okay.
And also the prima facie evidences which are available during the first round of investigation by the investigating agency. And based on all these facts and circumstances, the court, by its judicious mind, decides whether that particular accused, has the right to be enlarged on bail or not. Now, it is not the only case where the bail has been rejected. There has been many such cases in which the courts found that it was not appropriate to enlarge a person on bail, considering the kind of seriousness of the offences alleged, the statements made by the victim, and also in this case, there has been a statement further made before the concerned magistrate under Section 164 of Criminal Procedure Code, and that confirms the statements made in the FIR. So that is supportive of each other. So yes, the court feels in this case that the accused is not supposed to be enlarged on bail. However, till the time the accused is proven to be guilty, any accused has to be considered to be innocent unless and until it is proved by the court.
That is a fair point. Yes, I mean, yes.
Yes. Yes. So now the trial will continue based on this, and the charge sheet, if not filed, will be filed. And when the investigation is complete, the accused can again file for bail that the investigation is complete and I have cooperated in the investigation. Now, again, the court will see as to what has come out in the charge sheet. Is there any sufficient evidence for the crimes which have been alleged to have committed by the accused? And if that supports, again, the court may reject, but that depends on the court's
jurisdiction. But you know what is important, Mr. Srivastav, and I want to come to that point with Advaita as well, that the message that is sent across, what we are interested in as stakeholders, because these are criminals, perverts, lurking in our society. I'm not saying in this case, but there are. And there has to be some system in place. I want to ask you, Advaita Kalak, moving away from the legalese, the point is that as a close observer of human relationships, you would know this, that it's not uncommon. One shudders to think what a girl goes through. First, the man wins her trust. This is a case of a breach of trust, fundamentally. Gives all access to the man. There is a fallout. And then the woman is threatened with private photos. It's not an uncommon narrative. There are many cases where the families don't know about the affair. The girl would be petrified for the release of photos, and she can be easily arm twisted. It could go unnoticed. So how do we curb this pattern? Can the courts help, or do we need some other mechanism, Advaita Kala?
I think this is a very, very welcome decision by the courts. And I think it should set a precedent for this kind of behavior. And you're absolutely right. This in particular is a POCSO case. So it's taken with a lot more seriousness, as it should be, because there is a minor involved. But this happens all the time with adult women, with teenagers, with girls in colleges, women in their 20s, 30s, 40s. I mean, there's a term for this. It's called revenge porn. This may not necessarily be the case in the case that we are discussing right now. Mm-hmm. But if we were to look at it from a broader perspective, absolutely. The fact that the internet never forgets, the fact that everybody today has a platform, has an audience, and can make public intimate photographs, intimate conversations, which involve an exchange which was done with trust in privacy, and it can be made public. Now you match that up with a society which is very judgmental of women and girls. Even when there is a rape, they say, we've had ministers say things like, us samay kyun bahar nikli thi, ye kapde kyun pehne hue the, etc., etc. So you have a society which is extremely judgmental of girls. So this kind of mechanism, this weaponizing of trust, of intimate moments, to put women in the dock, to make them guilty of transgressions that society views as a certain way, thereby denying them the right to justice and the right to victimhood in situations, is something that is well practiced, which is well known, and continues to intimidate girls. You have girls who take their own lives. You have girls who withdraw from society, plunge into depression. There is the legal aspect of it, but there is also the emotional, the mental well-being aspect of it as well. So I think it's exceedingly important that the government comes down, the courts especially, come down very strongly on this. The police registers these FIR. We've seen far too many cases, even in Haryana where I live, where there are FIRs and stalkers are just allowed to carry on with their lives, and they go ahead and attack the girl, kill the girl. All kinds of situations happen. So I think we have to take this exceedingly seriously, because this causes so much mental and physical trauma to victims that we cannot look the other way.
Because, even under the Justice Verma recommendations, Mr. Srivastav, and I'm reading it out, where the committee has suggested the use of words, acts or gestures that create an unwelcome threat of a sexual nature should be termed as a sexual assault. So by that logic, this is not just another blackmail or intimidatory tactic. It is, as per this suggestion of the Justice Verma committee, this falls under sexual assault. What would you say to that? And interestingly, the court here says that every family with a daughter would understand. So looking at the humane side of it all, Mr. Srivastav.
Yes. Considering all the investigations so far and the documents and the statements also under Section 164, the court could reach to a conclusion that there are certain prima facie evidences that suggests that the particular accused would have committed such an offense, and his custodial interrogation is required and he should not be granted bail. That is absolutely correct. Obviously, see, there have been many different kind of instances. Obviously, in the society, such kind of heinous crime should not be tolerated. And it is really welcoming that the courts have taken a serious view on all these kind of cases. But at the same time, I also feel that there have been cases in which the accused have been acquitted also. There has not been anything which has been proved against the accused, and they have been released. So those things are also happening, and there should not be any misuse of law at the same time. But in the present case, as it is related to a child's abuse, who is minor. So these kind of cases have to be taken seriously, and yes. It has been rightly recommended that such kind of gesture has to be considered as the sexual harassment to the young girls or the boys, so far as POCSO is concerned.
Yes, absolutely. And on that note, and this is, like I said, this is an important step. It's time to widen that ambit of sexual assault. There is voyeurism, there is stalking, all of it are criminal offences. And in this case, the court has made some terse comments on this kind of a pattern which is simply not acceptable. Minor girls being arm-twisted to get into physical intimacy by threatening with nude photographs, something that the court has taken an exception to when it comes to giving bail. We'll leave it at that. Thank you so much, Advocate Aggarwal and Ashutosh Srivastav, for joining us today.